it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. Morning, are you Caden Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense. Not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one.
No, Judge.
Make that states two, because this one was the plea admonishment documentation, please.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
But I think that's enough.
Okay.
Would you switch that back to the other?
All right, I thought I did. Yeah, back on camera image.
HDMI two.
Oh, you want to
Try one.
Okay. Well, HDMI one is the laptop.
HDMI two. Any other evidence or witnesses?
So just brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor. Just
Mr. Rojas, you may make argument part.
Thank you, Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontainet's defense, he is a young offender. I know the court is tired of hearing the same story over and over, and young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision, or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, he's trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road. If this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. Because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Plan on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all of that stuff's fine, but you, Judge, where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. you are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Uh, uh, Judge, I'm just asking. I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club apartments who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff. Good morning. Are you Paul Jackson? And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Jackson, in clause number 26, DCCR 0112, you're charged with a first-degree felony offense of aggravated robbery. And that's from January 5th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Please.
And are you pleading guilty because you did what they charged you with?
Yeah.
So I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. It shows me that there is no agreement in your case and that you're leaving your punishment up to the court. Is that correct? So you're wanting probation. The state is asking me to send you to prison. It'll all be decided when we come back here later. And I look at the underlying offense. I look at any evidence that your attorney brings me, anything that the state brings me, and then I can decide to sentence you anywhere in the range of punishment, which is from probation up to between 5 years and up to life in prison. Do you understand? Do you understand?
Yes.
And there's no agreement, which means you would have some rights to appeal depending on how that goes and what I do. Do you understand that as well?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. I also want to make sure, Mr. Jackson, that you understand you have an absolute right to have a jury come in and determine 2 things. You can have the jury determine if you're guilty or not, and then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? So you can either do what you're doing today, that you've signed on the paperwork and leave your punishment up to me, or you can go to a trial and let a jury decide. Okay. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
I'm done speaking English, so I'm translating.
Thank you very much. Argelio Arellano. I'm sure I did not say that even close to right.
What did you say? I didn't hear you.
That I try.
You gotta do it, man, Judge. You gotta do it again.
I know. And for the record, Mr. Rojas, you're going to translate for us. Is that correct?
Yes.
Good morning, sir. Are you Argelio Arellano?
Yes. Good morning.
Me contesta en español. Eso está bien.
Sí.
Yes.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Arellano, in cause number 21-38292, you're charged with a 3rd-degree felony offense of smuggling of persons from July 28th of 2021. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yeah. Yes.
Do you fully understand them?
More or less.
Well, let's go through it. Do you understand that if I follow the agreement that you made with the district attorney, that you will not be able to change your mind or appeal your case?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
Is there anything else that you don't understand that you want to ask me about?
Well, that's all.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Arellano is not competent?
Oh, yeah.
Right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of smuggling of persons. Sentence you in accordance with that agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. So you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish. Please read it carefully because possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Rojas.
Thank you, Judge.
Still nothing from Mr. Bynum. Yeah, that was. Thank you, though. That's sweet. All right. I wonder if anybody's here. Is anyone here for Louisa Magruder? Just in the audience? We're just trying to figure out where her attorney might be.
I have not.
Okay.
Not from the phone or.
Is Mr. Lewis back there working on some stuff? All right, we'll just let him work on. Good morning. Are you Sebastian Cepeda?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Cepeda, in cause number 25 DCCR 0310, you're charged with the state jail felony offense of theft from a person, and that's from February 5th of 2025. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, you go over them with Mr. Lewis.
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Cepeda is not competent?
No, Judge, there is to competency, but I was made aware after speaking with his mother that there is some mental health issues where he has not done his medication.
Okay.
So as far as any.
We'll make that part of probation. Okay. Is there any restitution?
Judge, we sent our standard, the short answer is no. We got our standard restitution letter and we did not receive a response back.
Okay. Any reason not to waive the pre-sentence report? Do you anticipate that there would be based on the facts? Let me look at this.
Well, Judge, the allegations are that this defendant was in the process of a theft from a vape store, and in the process he pulled the clerk. Yeah, it's not that egregious.
I'm just saying, but nothing was actually taken, so there wouldn't be restitution. So no reason, no history to speak of that I need to be
just some
concerned about.
juvenile history, Judge. He does have a couple of pending cases in Refugio County, but as far as I know, they haven't been adjudicated.
Okay. And then, Mr. Cepeda, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That's going to include following any treatment and recommendations for any type of mental health issues that you have. If that means going to Spinal Tap or a doctor or wherever you live, something similar to that. If they recommend that there's medication you're supposed to be on, then you will be required to take that now as a condition of probation. Follow through with any counseling and all of that so that you'll be successful on probation. Do you understand?
Yes, ma'am.
It looks like it's trying, but I'm going to hand you in just a minute the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you today before you leave the courtroom and give you some documents so that you know when you're released that to go straight to the probation department so they can get you started and everything you need. Okay.
Yes, ma'am.
All right. Good luck to you, sir. Here's that. Oops. Sorry.
On the back row here. Please.
Hakeem Thomas.
Hakeem Thomas. Yes.
I think that's it. Now, the ones that don't have it.
They will be off there.
I can see that. I swear.
Good morning. Are you Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. What is the announcement?
In this situation, we've had several pieces of mitigating information that's come through from my client's family. I've been speaking with Ms. Mofino about this, and I think now we have a definite plan as far as going forward with this case. We're not at the point of where we want to place on the trial docket or anything, so we just would like a little opportunity to see if we can get this resolved.
Okay. One normal reset.
Yes, Judge, I believe that Mr. Thomas's parents are in town for a meeting with Mr. Lewis. I have expressed things that I would be hopeful that they would discuss that may change some of our points of view, just in order to keep the dialogue open amongst all of us. There is also a co-defendant, Mr. Hartley, in this case, who has flatly rejected any offers, of the state. So I've asked Mr. Lewis to take that into account with respect to those discussions. So a reset, I think, would be timely if the court would
Sure.
allow.
All right. I'll just do a normal reset. That way, Mr. Lewis can get everything, visit with your family, get any information, get that to Ms. Malfino, have some discussions and see where we are at that next court date.
Judge, I just want to mention, I'm talking with Ms. Mofino, I think it's a possibility that there is some more discovery that may be coming available. And so I may need a little time to, if it
Sure.
does, so I have time.
And that's the same issue we had last week with Mr. Wilkerson's client, Mr. Hartley, that we have reached out to Belmont, have that. It's what I'm waiting on is from the out-of-county task force officers. I'll follow up again this week.
Okay. Sounds good. Thank you very much. You can go back with the bailiff.
Thank you, Judge.
Gregory Griffin.
Griffin.
Good morning, you're William Bonilla. And so, Mr. Bonilla, this is your initial appearance. You have two cases. You're on probation, and there's been a motion to revoke your probation filed in cause number 25 DCCR 0174. And you have a new indictment in cause number 25 DCCR 0719, charging you with evading arrest or detention with the use of a vehicle from May 10th of 2025. And since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? Okay. Trying to see who set a bond and Oh, here it is. It's probably fine for right now. It'll get the defendant, I think. Dylan Wilkinson. Good morning. Are you Dylan Wilkinson?
Yes, ma'am.
Let's see. Mr. Wilkinson, this is your initial appearance in cause number 25 DCCR 0260. You're charged with deadly conduct, discharging a firearm from September 13th of 2024. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, not just yet. No, I was gonna ask if I could have a little bit more time in order to come up with more funds to hire an attorney.
So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice.
Cordell, Beard,
Brianna Kleinan. Brianna Kleinan. That's not one of the ones.
No response, Your Honor.
Her bond will be forfeited for non-appearance and reset at 100,000. Okay. Mark Garcia. If you'll call the name Mark Garcia. He called.
Mark.
Let's see.
No response, Your Honor.
All right, he did call and say he was going to be late. I will issue a bond forfeiture for non-appearance and reset his bond at 100,000. If he shows up, just let me know and I'll recall that. Drayden Rose. Good morning. Are you Drayden Rose? And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the 3rd-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm in court.
How old are you?
18.
Are you still in school?
I got my GED.
You got your GED?
Yes, ma'am.
So are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of erasing your bond and you would have to go back to jail for not following that court order. Do you understand all that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Lance Charbino. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey is Crenshaw. He asked for 4,000 down.
Okay,
And as soon as I get that, which should be about 3 weeks from now.
okay.
And then I'll be able to get him hired for.
All right. You've been here a few times, so I'm going to reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not going to work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right. Step in front of the clerk. She'll give you a reset notice. Presley Viltz. Good morning, you're Presley Viltz. Did you get someone hired, Mr. Viltz? No. Who'd you talk to? Okay, did you write down the names? Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talk to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them.
Yes, ma'am.
So what part of bring me back the names of who you've talked to did you not understand?
I understood. Okay.
You just forgot. Okay, so you're in felony court. You don't just forget, because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them. Did you talk to 3? You really talked to, so when you first answered, you said you talked to 2. So be careful what you're saying. All right. And you're probably nervous right now, and I get that, but be careful what you're saying, because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute, because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge. Let me know about where you're working. Bring a pay stub when you come back. The more information you bring me, the better things are going to go. Does that make sense? All right, 2 weeks. Step in front of the clerk. Caitlin Talmore. Good morning, you're Caitlin Talmore. And Ms. Talmore, this is your initial appearance in cause number 25 DCCR 0595. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail. Do you understand? Yes. All right, step in front of the clerk. She'll give you a reset notice.
Sign.
Janisha Leonard. Good morning, you're Janisha Leonard. Let's see, and Ms. Leonard, you have 2 motions to revoke your probation. And then you have a new case in cause number 25 DCCR 0297. And I set bonds and you've made bonds on all of those. And have you had an opportunity to hire a lawyer? Okay, so you need to get someone hired. The fact that I set those bonds at what I did, even when the state asked me not to, you've got some serious stuff going on. You need to try to get someone hired if you can before that next court date. So I'm going to reset your case for 30 days. You need to try to get someone hired. If you do, bring the reset notice to them. They'll tell you what to do. Go ahead. Well, you need to try to get a job first. And you need to apply to at least 5 jobs a week, and you need to bring me proof of that. Okay, if you do get a job, bring me some proof that you have a job. In the meantime, I'll also want you talking to lawyers. Bring me back the names of the lawyers you've talked to, at least 3, so I know you're trying. Bring me the information about that you're trying to get a job, and then we'll discuss all of your options. Okay, if you don't do that, then your bonds will be raised, especially on those motion to revoke probations. You'll be right back in jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. How'd you make all those bonds?
My family came together.
Okay, well, you might need to get with them on this too.
Yes, ma'am.
Okay. I set a bunch of bonds on motion to revokes today. I look back and I think, what was I thinking? Anthony Salvato, this is another one. Because I don't usually do all of this. All right, you're Anthony Salvato. Mr. Salvato, you're here on a motion to revoke your probation, and I set a bond in your case. Let's see, I feel like we had received some letters. You were participating in the veterans and all of that.
Yes, ma'am.
You're still doing all of that?
Yes, ma'am.
Good morning. Good morning. What is your name for the record? Okay, and who are you with, Ms. Branch? Okay, thanks. Sorry. And so has he been following through and everything with regard to probation? Okay. Have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right. Are you working?
No, ma'am. I've been trying to do the program that we have. I have had a couple of interviews, which I have not been successful because of my record, my health diagnosis. It's been very difficult. I have attended some veteran work job fairs, and that was unsuccessful as well.
Okay.
So, but I have been trying, and I am seeing a employment counselor once a week.
Okay. What I'm going to do this morning, Mr. Salvato, and I'm looking back, I have some documentation from the Veterans Association and things like that with regard to when I set your bond. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. All right, step in front of the clerk. She'll give you that paperwork. Thanks, Ms. Branch. Sorry, I didn't recognize you. I didn't know who. I don't know if I've seen her in here. Daryl Spencer. Good morning, you're Daryl Spencer. Mr. Spencer, did you get someone hired? Did you already hire him?
I was on him today.
You're okay.
I had money on the leg now.
Okay. Did you talk to him about where you were going to meet, or?
I told him about my case and stuff like that. He told me to make a payment plan with me because I talked to Marcia Bowman and she told me she couldn't.
Okay. So you have the money to hire him?
Yes, ma'am.
All right. I'm going to reset your case 2 weeks.
Yes, ma'am.
You need to get him hired before that next court date.
Yes, ma'am.
Right. Step in front of the clerk. She'll give you a reset notice.
Yes, ma'am.
I do too. I do too. I can't remember for sure, but I think so. No, from before. I can't remember.
Let me check your share.
I know, she'll remember. I'll ask you later.
Thank you. Yes.
Yeah. I appreciate today that solid. Better choices. I wish I had said something now. He knew. He knows he went viral too. Poor thing. He might be. Somebody. I know, right? Kyle was in here. I know. I was going to try to get him first because he was being on time and patient.
Judge, if you want to run, Gertz is not going to be here.
He's
in trial.
Oh, yeah.
And I have his announcements. If you want to.
All right. On, let's see, Ms. Malfino's case on Dustin Knight, that's a pretrial. Mr. Gertz is not here, but his announcements.
Just read that.
I have filed and agreed.
That's on the
That's
other
in the
one.
other one.
That's the one I've got.
Okay.
I believe she is ready, Your Honor.
Okay. And they were talking about a possible resolution last week, but they didn't do that. So if you'll get with them, her. All right. Then I'm going to number, is Dustin Knight here? Did you tell him not to be here?
They didn't.
Okay.
They're not going to.
And then on Jesse Salinas.
We spoke, last week, Judge. Me and Mr. Gertz.
Uh-huh.
We're close, we're 3 minutes before 1 hour, one recess, we'll be ready at that time.
Okay.
I've got all my witnesses, claiming witnesses in Florida, I've got witnesses out of state.
Okay.
But I've talked to him about it and he's all right.
I mean, they'll still be out of state next time, right? Okay.
But we didn't, I don't.
I mean, I didn't mean to be
I'll-
smarty about that. I'm just
No,
saying.
no, I understand, but that's, we were in agreement on that. I don't think he was ready as well.
I gave you a trial.
But a quick recess.
Okay. You did, Kelly.
Yeah, we're doing the bond ones today since we're off next month.
Oh, this is for trial in
2 weeks.
2 weeks.
2 weeks. I meant to call you, but your email.
Okay, I'm going to grant the motion for continuance this time in Mr. Salinas' case, but there will not be another.
Yes.
Thank
No
you.
problem.
And if you'll just relay that to Mr. Gertz
I
as
will,
well.
yes, ma'am.
Yeah. Good.
Judge, can we call Mr. Mitchell's case on Van Wright?
Morning, Your Honor.
Good morning.
Sure, this was one,
John Van Wright. Good morning, sir. You're John Van Wright. And this is 24 DCCR 2485. And then there's the motion to revoke probation in 15-23582.
Judge, I know Mr. Mitchell was trying to get with Mr. Smith. He didn't realize he was out last week. He was having trouble watching the video they need to watch. I know enough about this case to know they need to watch that video.
Okay.
So I'm asking for a reset so they can do that.
Okay. I will do just a normal reset. Obviously, if there's any issues, if you can get with Mr. Nichols or Ms. Malfino, I'm sure either of them will help you work that issue
Absolutely.
out, and we'll get an
I think it just
announcement.
wouldn't play for him, so he was going to come to our office and do it.
Okay.
If he needs me to do it for him, I'll gladly do it.
Okay.
so I'm setting trial this morning in the 128th with Mr. Gertz. We're both under trial protection.
Okay.
As soon as that ends, I'll give Mr. Nichols a call. And we'll go to
Perfect.
their
And
office.
Mr. Smith might be back by then as well. And so, but if not, just get with Mr. Nichols or Ms. Malfino. They'll help you out. Okay.
Thank you, Your Honor. I appreciate it.
Stay in touch with Mr. Mitchell. He'll let you know when you need to be back. Thank you. Mr. Walker, are you ready on Adrian Housley sentencing?
Yes, ma'am.
Good morning.
Good morning, how are you?
Good. How about you?
Doing good.
What we're talking about, I have an intention to try and read her. That's all in this announcement document.
Oh, for next, yeah, in 2 weeks. It's one of those names that are on my list that I'm tired of seeing. It's you too, I'm sure. Good morning. Are you Adrian Housley?
Yes, ma'am.
Mr. Housley was previously in court, entered pleas of guilty to, or plea of guilty in cause number 25 DCCR 0290 to theft of property with previous convictions. It's a state jail felony. And we pled it as, no, and there were prior offenses. And so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been in the penitentiary numerous times. So I leave it to the court's discretion whether or not it wants to place this individual on probation or in light of his history.
The underlying, what he ended up pleading to, was it a third or a second?
Second. 20 because it's so big.
That's what I wanted to make. Okay.
Yes, sir.
Okay.
And Judge, if I may,
Mm-hmm.
what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself. And that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop or you just keep staying in prison. Are you still working at Dragon Products?
Yes, ma'am.
You've been, I mean, it looks like you're following through with your, is it the veteran services and Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered the plea of guilty freely and voluntarily.
Yes, ma'am.
I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years.
Yes, ma'am.
And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the specialized mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of two sides to this, right? And so deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for you. Because now that 10-year cap is gone. I didn't send you to prison. So if you do your probation right, then you won't have this conviction.
And if you're successful at the end, the case is dismissed and you will be able to continue living your life like you have been, it looks like, for the last 16 years or so.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you're back in court, you're found guilty, which means you have the conviction, and I have the entire range of punishment, which is up to 20 years.
Yes, ma'am.
And on paper, that's what it looks like you will deserve at that point if you don't take advantage of this. So I hope you do. I'm going to hand you the trial court certification that shows this was an agreement I followed, so you waived any right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Yes, ma'am. Thank you. God
Yes,
bless.
sir. Thank you. You too, sir. Thank you, Mr. Walker.
Thank you. Excuse, Judge.
Yes, sir. Mr. Boudreaux, you've got David Holland. Mr. Boudreaux, you have David Holland.
We talked about the case, Judge.
Thank you, Mr. Coleman.
Morning, Judge.
Good morning.
Good morning, Judge.
Good morning.
You never responded to my calls of late.
Okay, we'll see if he's here.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at 100,000.
Thank you.
Thank you. All right, thank you, sir.
Zoe and Zoe Palisade. Thank you.
Okay. Michael White. Good morning. Are you Michael White? And Mr. White, you are on probation and cause number 23, DCCR 1117 for the third degree felony offense of driving while intoxicated, third or more. And probation sent an administrative hearing. It looks like as part of your probation, you were ordered to enter and successfully complete the SAFE program. And that was in order to have a SCRAM device. When you got out of SAFE, it looks like you obtained the SCRAM on April 8th, and then they notified probation that you were not meeting your financial obligations, and they terminated that, and so you don't have the SCRAM anymore. Is that correct? So, are you working? Why not? Where have you looked? What different places? Speak up, please.
Home Depot Road. Construction company.
Okay. Has he given you notification of all of that?
He has, he also gave me an award letter from Social Security.
Okay.
He receives, I think, with $400.
He's under review right now.
I can't hear you.
He's under review right now.
Okay. So that was just a partial disability.
Yes, ma'am.
Okay. Well, I guess an option is for him to come to the office more often to take alcohol tests there.
He is kind of frequently, he's on a color code where he calls everyone, and when they call his color, he comes in and does units. He also does the outpatient portion of safety, and they UA him frequently as well.
But are they also doing alcohol testing?
Yes.
Okay. And everything's going okay with the
He
outpatient?
hasn't had any.
The only issue is the scram.
Yes, he's going to group meetings and all
Do you drive? Okay. So here's what I'm going to do, Mr. White, based on your income and the partial disability, I'm going to retract that order that you have a scram device. I'm going to order that you continue with the drop program, follow all of those rules. Obviously, if you test positive for anything, including alcohol, you'll be right back in here. Also, as of now, a condition of your probation, since you cannot have the scram or can't afford it, is that you do not drive. So you cannot drive any vehicle at all ever without further permission of the court. So if you get to a point where you have the ability to get a car or drive, you're gonna have to go through probation, request permission, and then I'll have to take a look at how you're doing and what I can do to make sure that I feel like everybody's safe. Does that make sense? Okay, anything else you think? All right, keep doing what you're doing. Thank you, sir. Let's see, Mr. Burbank, Ms. Cawthon, you have Ashley Riggins at the sentencing.
Yes, Your Honor, she's outside the door.
Ashley Riggins, it's Mr. Hoffpowers. There's not? Okay, why? What did I do?
I don't know. I haven't noticed.
Okay, I need it pulled up so that I can.
I'm sorry, Judge. I didn't realize that's what this was.
I'm sorry. It's okay. I just gotta see something that tells me what to do. Usually Anna does something over there and then it comes to me here. Okay. Y'all are gonna have to give me just a minute so I can. Because also we'll need the certification. You want me to hold it for a second?
Yes, please.
Can y'all just have a seat real quick? I just so that we can get all that paperwork pulled up. You're good. Yeah, just stay in the courtroom, please. Is Mr. Comerford here?
Yes, Judge.
Good morning, sir. On Shadamon Mitchell?
Yes, I just see that the paperwork.
Good, I'm sorry right now.
Okay, I'll recall it as soon as that paperwork comes through. And then, Mr. Comerford, you also have Ronnie Oliphant?
Yes, and then I have Simon Gobbard as well.
Okay, are you ready to announce on Oliphant?
Yes, I'm just preparing discovery for them.
Ronnie Oliphant? Good morning, sir. You're Ronnie Oliphant, and this is 25 DCCR 0379. And what is your announcement?
I'm still reviewing the discovery with Mr. Oliphant.
Okay. Any issues, Mr. Coleman?
No, Your Honor, and we're not opposed to reset.
All right. So we'll do another about 30-day reset. Mr. Oliphant, make sure you stay in touch with Mr. Comerford so you can go over all of that information and discovery that he's received, and then we'll try to get an announcement at the next court date. All right. You're free to go. Thank you. And then Simon Gobert, you're here for Mr. Flory on that one, Mr. Comerford. Yes, thank you. That's okay. So let me print out. All right, sir, you're Simon Gobert, and this is cause number 24 DCCR 0512. Mr. Gobert's charged with attempt to commit sexual performance by a child. What is the announcement?
I'm still reviewing the discovery with Mr. Robbery.
Okay. This case is old.
It was re-indicted, Your Honor. Have you got everything you need, or?
Yes, I think I'm missing something, but we can talk about it.
Let me know what it is.
Okay. It looks like you substituted in, y'all substituted it just in mid-June.
Yes.
So I'll do one more reset. Get with Mr. Hoffpower. He'll work with you on whatever you don't have. And I'd like to try, even though you're fairly new on it, I'd like to get an announcement at that next court date. Make sure you stay in touch with your attorneys so that you can visit with them about everything and we'll know which direction your case is going to take at that next court date. Okay, thank you.
Thank you.
Ms. Coffin, y'all can come back up on Ashley Riggins. I'm printing the certification. All right, ma'am, you're Ashley Riggins. And Ms. Riggins was previously in court, entered a plea of guilty to unauthorized use of a vehicle in cause number 25 DCCR 0092. The agreement was for 15 months in the state jail prison. We didn't order a pre-sentence report. Is there any reason not to go forward with sentencing today?
No, Your Honor.
And Ms. Riggins, have you gotten into any trouble since your last court date? Okay. Then at this time, I am going to find that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody on this case that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right, good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Coffin.
May I be excused, Your Honor?
Yes, ma'am, thank you.
Thank you.
See, Mr. Kimler, you have Ariana Evans. It's a sentencing. It's a sentencing on Ariana Evans. All right, ma'am, are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor. No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay,
It's not being tracked at this point.
okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right? I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which do you, what do you want?
if I can do the 60 days that they offer me and, be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today.
Yes,
So,
ma'am. Okay, so, I'll let it be reinstated.
okay,
It is a misdemeanor, you know,
I understand. Go ahead.
and obviously the easy way for her to address this situation is to take the revocation and take guilt out on it. However, the defendant's version does indicate some mental health issues. And obviously probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, that I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow the, maybe the recommendation, you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an what do they call antisocial personality disorder, whatever her issues are, the mental health standpoint.
Did you see that somewhere or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with
Okay,
obviously things that can be dealt with. in therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask we revoke her.
so Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive. You were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You'll need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Can I get my phone and my system?
Talk to the bailiff. Just talk to the bailiff. Yeah, come over here and get a thumbprint, please. Here's yours. And then, Mr. Kimler, you have Raquel Glover. Mr. Nichols, this is Raquel Glover.
Yes, sir.
Sir, are you Raquel Glover? And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection on Monday the 8th. And what is the announcement?
Your Honor, the state has tendered an offer of 5 years in this case. They've also indicated through a notice of enhancement that the punishment range will be a second degree, 2 to 20, because of a federal conviction Mr. Glover has. He's refusing the 5 years and we're asking you to continue. Is that correct?
So I want to make sure you understand. Are you ready?
Yes, Your Honor, state your.
And so, Mr. Glover, I will number your case for trial on that date. It's one of the older ones, so you need to be prepared. Talk to Mr. Kimler for trial. I also want to make sure you understand that after today, I will not accept that plea agreement. And so if you change your mind after today, you can enter a plea open to me or to some other agreement, but it's not going to be to that agreement for 5. Do you understand? And you want to go forward with your trial in 2 weeks. All right, stay in touch with Mr. Kimler, and we'll see you back on Monday, the 8th.
Thank you, Your Honor.
Mitchell. Mitchell.
Mr. Kimler, you also have Johnny Polanco. I'm ready. All right, sir, you're Johnny Polanco Senior?
Yes, ma'am.
And this is 24 DCCR 2168. Mr. Polanco's case is set for trial to begin with jury selection on Monday, September 8th. And what is the announcement?
I'm ready, Your Honor. This is the one the court will recall. And
It is.
It is. He's not here.
I was mistaken, Mr. Sheriff or Mr. Smith. The other case that he was arrested on was referred to the federal authorities. There's still been no action on that.
All right, so we'll go forward with this one.
We're ready, Your Honor.
All right, the case will be numbered for trial. Mr. Polanco, stay in touch with Mr. And has there been any change with regard to negotiations or anything like that? All right, so your case will get numbered for trial for the 8th. Stay in touch with Mr. Kimler. He'll know that trial order tomorrow after the docket and let you know when you need to be back. Okay? Uh-huh. I know I haven't seen, no, not yet. Thank you. Who's she here for? I'm just trying to, or tell me what page it's on. I'm looking. See. I just missed it. Devin Spites, let's see, see, Ms. Hawkins?
Yes, ma'am.
Good morning, Ms. Hawkins.
Good morning. Mr. Spicer has not arrived yet. I spoke to him last week, not this morning.
If you'll call the name Devin Spites, please. Go ahead.
The court informed me that the bondsman made contact, so that he's got a wobbly tire.
That's, yeah. You have a picture? He did let us know that the bondsman know that. It does say that he's on his way though. And so what I'll typically do is go ahead and announce the bond forfeiture. If he gets here, I'll just recall it. So if you'll just.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at 100,000. Obviously, once he gets here, I'll recall that. So if you'll just kind of let me know or let the bailiffs know when he gets here.
If he does not get here, how do you want me to handle the motion to withdraw? Is that electronically or?
Did you file a motion to withdraw?
I did not file.
Oh, well, then you'll need to get that filed. Yeah.
Get filed.
Yes, ma'am. Everything's got to be e-filed.
That's what I thought.
Yes, thank you. Let's see. Mr. Comerford on Shadamon Mitchell.
Here's the discovery.
Thank you. And you'll get that, make sure and get that attachment emailed to the clerks today, please. All right, are you shut him on Mitchell? And will your client waive the formal reading of the indictment?
She will.
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution.
Yes, ma'am.
Okay, I'm
We're okay with it.
inclined to reduce that. I'd much rather the restitution. How old are you?
25.
Okay.
We're okay.
So the restitution would be $3,999.68. Is that your understanding?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There's not.
And is there any reason not to go forward today since y'all have the restitution amount?
Judge, she doesn't have a criminal.
All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm sorry, did you just do something? I'm seeing movement. I thought so.
I'm sorry.
That's okay. I thought she needed something on your case. All right.
I'm so sorry.
No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? So $4,000 is a lot of money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately, even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months. And all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right. I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again. I don't need to see your belly button in court.
Oh, yes, ma'am.
Okay. You're in felony court. Dress appropriately. That's important. It's time to kind of grow up. You're on a felony probation. You need to do things in an adult way. And dressing like that is not an adult way to show up to court. Okay. You need to have a seat here in the courtroom. Probation's going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay. Good luck to you, ma'am. Thank you, Mr. Comerford.
I'm ready.
That's real Crocs.
One of the forfeitures showed up.
Oh, I think that's what I saw was the sticky. Is Mr. Frank here? Jonathan Frank? Mr. Gallimore, you have James Rucker, 2 cases.
Good morning.
Good morning.
Judge, we are winding down on this. We got an offer since our last court date.
Okay.
It has $80,000 in restitution. So what we're asking the court is give us a little bit more time to vet that, the proof of services for that, and see if there's something that we could come up with up front to help resolve the case. I did find, I looked and couldn't find them. I did find though the proof of services for that 80,000. So we need to go through it. He has
Okay.
not seen it. That was added in discovery at a later date than when he came to my office the first time.
Okay. Any issue?
No, if you recall, when we first came in here, we were still waiting for.
Right.
Because the cleanup was still.
Right. And so y'all got everything's
Finally got
here
that.
and you've got it all?
Everything's here.
Okay.
The offer's been sent. We should be
Perfect.
done today.
So we'll do one more reset, and Mr. Rucker, make sure you go in, visit with Mr. Gallimore, go over all of that discovery so that we can figure out an announcement at your next court date, which direction your case is going to take. Okay? All right. Thank you. Mr. Lewis, you have Paul McCorvey.
Yes, ma'am, Judge. Mr. McCurry called my office this morning, but I haven't seen him this morning.
If you'll call the name Paul McCorvey, please. Oh, but he did call here as well.
Did he? Okay.
But he was coming just late. Is that what?
That was on you can't memorize.
Okay.
Mr. Sean is past vacant.
Good.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at 100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You
said,
got Kira's aunt, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone. So I'm assuming he is trying.
Maybe on his way. Okay, thank you. And then you've got Kira's Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Karis Antoine, and this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge, and we contacted them this past week asking for an update. They hadn't gotten back with us yet. I even
Okay,
had Mr. Hoppower call because he's used to dealing with them.
right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to them by email.
Okay.
But we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me an
expect them?
update, But it was Friday.
Okay.
I got last contact.
She's usually pretty responsive. All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you. Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoppower's voicemail. Sound about right? 2 minutes, will be?
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
You can handle it.
Next game.
Mr. Rojas, you've got Carnell Beard. Morning, Mr. Rojas.
Morning.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He would, Your Honor.
Are we going on count one? Oh, no.
No, ma'am.
Okay.
Everything.
Okay, let me, all right, and he'll waive the formal reading of the indictment.
Here we are.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge,
do we just need to go on one, or
Let's
is
just
that?
go on one because I'm looking at the dates and they do overlap, so it would not make them.
It wouldn't, so it makes it a second-degree felony. So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced,
15
but
and 99 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have, since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count 1 only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement, unless there is new information that your attorney or the district attorney's office receives. Do you understand? Okay. If you'll just have a seat, she'll call you up in just a minute. Mr. West, do you have Michelle Johnston? Good morning. Michelle Johnston. Good morning. Are you Michelle Johnston? And this is 23 DCCR 2260. What is the announcement?
Your Honor, me and Mr. Coleman have been talking. We have an offer on the table for some restitution to be paid. My client has indicated she needs some time to come up with that. So we'd ask the court for as much time possible to come up with that money. She's recently served some time in federal prison, so she has lost a lot and has filed bankruptcy, so is having some financial problems. So,
well, the case is already 600 days old.
I know, Your Honor. Most of that was taken out while she was in federal custody. So.
Judge, I know we talked about the federal custody, but I didn't snap to that possibly being another avenue for us to resolve this case. Can we put this case on recall, Judge?
Yeah, let me hold it for a minute.
Okay, sure.
Okay. Ms. Holmes, you have Nakia Brandon?
Yes, Your Honor. This one for drug patch, just put on doc for drug patch issues. I think Anna had sent some emails out last week.
Yes. So I'll get a test this morning. Good morning, you're Nakia Brandon. So, Mr. Brandon, you're ordered to have a drug patch, and it looks like you've had some issues with that. Have a seat in the jury box. We're going to get you tested this morning. TJ Landry, looks like that's set for a plea.
I had a motion to withdraw last week. Yeah. He's been having a lot of financial difficulties.
Hold on. All right, this is 24 DCCR 0165, your TJ Landry. And this, it's been going on for so long.
If you need me to move it, I'll move it. But I've been patient with Mr. Landry to, fulfill his financial obligations, and he just.
Are you working?
I'm working. It's the hour. That's it. And I was out for like 2 weeks because she put this one car. The money I have for her there, I used to get my car going. I'm trying to fix this on the I ended up calling her ahead of time and told her, hey, I got my money to make the payment. I called her ahead of time. And then I ended up going to jail for expired registration tag on my car. So I had to pay for my title to be transferred.
The thing is, if he qualifies, it's going to be you because you were initially appointed, which isn't super fair. I understand. Y'all have something worked out?
There's an agreement for probation. I think the state is asking for straight. We're asking for deferred.
Okay.
I'll get the paperwork.
Yeah, it's going to be either way. I don't, on this one, just because where are you working?
I think so, I'm mobile right now. I just got this one.
When did you just get back to work?
Thursday last week.
When is your next payday?
Thursday. We get paid every Thursday.
What I'm inclined to do is, even though it's been going on, is reset it one time to give him some time to take care of some of the obligation to you, Ms. Holmes, and then we'll take care of it at the next court date.
Yes, ma'am.
I should be okay because I
You need to take care of Ms. Holmes. She's been working on your case very hard. And so it sounds like she's got a good offer for you. And now that you're working and you're working full time, I would expect you to hire someone. You've done that. You need to try to take care of that obligation. I'm going to reset it 30 days. I want you to get with her, take care of as much as you can with her, and then we'll take care of it at the next court date.
Yes, ma'am.
Okay.
Thank you.
Thank you.
Thank you, Judge.
Edmund A. Latulis, Ms. Holmes?
Yes, ma'am.
Maybe that'll help.
Yeah, thank you. Thank you. Yes, I'll call you. Okay.
All right, you're Edmund A. Latulis, and this is 24 DCCR 2057. Ms. Latulis is charged with abandoning or endangering a child, and what is the announcement?
Yes, Your Honor. So there's a co-defendant involved. Spoke with Mr. Hoffpower. He would like to meet with both me and the co-defendant's counsel.
Which I spoke to Mr. Burbank, who's here.
Okay.
Like, if you want to hold off on our announcement and make sure that we're doing that, but I think we have a resolution, but due to the nature of the facts of this case, which is a dead child, that's why I want to make sure we cross every I.
Well, and this one was, I have a notation that this one was going to go before the other one anyway.
Right.
Oh, I didn't know that.
She needs to talk to her client about what our offer is in regards.
Yeah, I was getting offered this morning.
Oh, okay.
Right. Now we've spoken.
Okay, so let me do this. I'm going to reset it, just a normal reset.
Okay.
That way you can go over any options with Ms. Latulis. Y'all get together, Mr. Burbank, Mr. Hoffhour, y'all have 30 days to take care of all of that. And I want an announcement at that next court
Yes,
date.
ma'am.
Okay. All right, Ms. Latulis, stay in touch with Ms. Holmes because you're going to need to go visit with her before the next court date. And then Zoe Valicilla.
I'm gonna, oh Lord, she signed on the wrong line.
Oh, that's okay.
Is that okay? Okay. I'm sorry, Lou. She had signed on the wrong line.
Okay.
All right.
Good morning. Are you Zoe Valicilla? And Ms. Holmes, will your client waive the formal reading of the indictment?
She will, Your Honor, and I'll email the attachment.
Oh, thank you. And Ms. Valicilla, in cause number 24 DCCR 1364, you're charged with a second-degree felony offense of burglary of a habitation from May 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 7 years in prison. And what that means is that you're leaving your punishment up to me. And as long as I don't give you more than 7, you're waiving any right to appeal. I can give you 7, I can give you less. It'll all depend on the information that's brought to me when we have a sentencing hearing. You have every right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Valicilla is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get with Ms. Holmes and get that information to her. She'll present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Zachary Turner.
See Mr. Frank. You see Mr. Frank?
I bet you he has a no-show before and he never filed a motion to withdraw.
Is DeAndre Smith here?
I'm sorry.
DeAndre Smith, will you see if they're here, please?
So wait till the
Bless you.
before you come back on the state, okay? So I'm gonna put your but again, wait till the morning.
Try this, Your Honor.
Good morning. You talked to your attorney?
Yes, ma'am. He's 6 months, 8:30.
Oh, he is coming?
Yes, ma'am.
Okay.
I had talked to him, he said he had talked to the DA also.
Okay, if you just hang out till he gets here, okay?
Yes, ma'am.
All right, thanks. No, it's fine. It's not even 10:15 yet. Mr. Burbank, you've got Andrew Jackson.
Your Honor, we have a deal
Okay,
with one caveat.
okay.
Yeah, let me-
I know every, yes.
Take a deep breath. He is going to plead today, and it's for 12 years.
Uh-huh.
The girl wants to come and make a statement, if we can reset it for 30 days or whatever it is.
We'll reset it for 1 week.
That's fine.
It's been reset enough. We'll do it on Tuesday on a jail docket. We've got jail here anyway.
He just needs to take care of some stuff.
He's got a week.
Yeah, that's what I'm saying.
Yeah, 1 week.
Because
it's not like this is a surprise.
No.
It's not. So
Yeah,
you had 30 days to take care of this and time to get them here. So obviously, everybody knows this is a bit frustrating, get the paperwork done.
But we're doing it right now.
And it will be 1 week to next Tuesday. Okay, all right.
He's going to take a plea now.
Okay, yeah, you get that paperwork done.
You'll have a secret paper.
Thank you.
And I have a Mr. Martin.
Do you?
John Martin. I did, but that's not.
Yep. John, you said? Mr. Kelly, you've got Raymond Ryder.
He's present.
Good morning, you're Raymond Ryder, and this is 23-41597. Mr. Ryder's case is set for trial to begin with jury selection on Monday, the 8th, and what is the announcement? All right, obviously this is quite old, so it's likely to be numbered at the top. Any changes with regard to negotiations or rejections that I need to go over? Hey, can y'all hold it down? All right, so Mr. Ryder, stay in touch with Mr. Kelly. He'll know tomorrow after my docket what the trial order is, but expect to be here on Monday, the 8th for trial, okay? All right, thank you.
Thank you, Judge.
Is it okay if I need to do it, make sure I'm waiting? I don't think they've come to drug testing
Oh,
yet.
yeah, sure.
Okay, I'll be right
Yeah,
back.
just let me know when you get back. You're good. Ms. Hawkins, did your client get here?
No, ma'am.
Not yet, okay.
I did follow to the draw, he didn't do anything I had.
Oh, you filed it
I
today?
just did it.
Okay.
You probably don't see it yet.
It will probably be tomorrow
Okay.
because of the system. And you got to give him notice of that as well. So we'll see if he shows up, but if he'll agree to it, I possibly can get that done today. If not, technically he's got to have notice. And so we would have to reset it for another date, but let's see if he gets here first. Okay, thanks. Mr. West and Mr. Are y'all
working on?
Okay, thank you.
In this courtroom, Mr. Watts was asking the judge for a chance at probation, while the prosecution argued that his actions, and even his behavior while in custody, showed that probation was simply not appropriate. The state pointed to incidents that occurred while Watts was in jail and argued that if he could not follow the rules while in custody, there was little reason to believe he would suddenly comply with probation. Because of that, the prosecution asked the judge to impose 17 years in prison in each case. But the defense presented a very different side of the story. Watts was described as a young man with no known juvenile or adult criminal history before these two cases. His attorney acknowledged that the offenses were serious, but argued that Watts understood the consequences of his actions and was genuinely remorseful. The defense also suggested that an older influence in his life, possibly his father, had encouraged him down the wrong path. Because of his young age and lack of prior criminal history, Watts asked the court to give him a chance at probation instead of sending him to prison. Then Watts had the opportunity to speak directly to the judge. He apologized for everything that had happened and said that he truly regretted his actions. He told the court that if he had the opportunity, he would apologize directly to the woman involved in the case. Watts also tried to explain some of the disciplinary write-ups he had received while in maximum security, saying that he did not believe all of them fairly represented who he was. The judge listened to his apology and acknowledged something important. Watts was still young, and regardless of what happened in court that day, he still had the ability to change his life and make better decisions in the future. But the judge also raised a serious concern. She explained that sometimes people are